Good morning, everyone. Thank you for joining us today for this important webinar on the upcoming changes to the Accredited Employer Work Visa scheme, which took effect from 10th of March this Monday. And we appreciate your time and look forward to providing you with valuable insights into these policy updates. Okay, before we dive in, let me introduce ourselves. My name is Maggie, and I'm a licensed immigration advisor here at Absolute Immigration. I work closely with employees and migrant workers, providing advice on New Zealand visa policies, making sure everything's compliant, and helping clients in workforce planning. And joining me here today is Hailey. She's also licensed immigration advisor. She's our expert on work visas and employer accreditation. Hailey's great at helping businesses navigate the immigration system and making the whole process as smooth as possible. So together, we will walk you through these key changes and answer your questions along the way. So here are some housekeeping tips. Before we proceed, a quick disclaimer. The information provided in today's session is for general educational purpose only and does not constitute personal immigration advice. So a reminder as well that we can't answer any questions about individual cases. So if you need tailored advice based on your specific situation, please reach out to one of us. We have a Q&A session for this webinar. You can start entering your question in the Q&A chat box from now, and we will finish this presentation by answering all live Q&A. Please note this recording of this webinar and the slides will be shared with you all participants after the session. So now let's go over today's agenda. So we will have an overview of AEWV changes, key changes effective from 10th of March this Monday, and a detailed breakdown of policy updates, impact on employers and migrant workers, and then finished by the Q&A session. Okay, so you will remember that in April 2024, there was a tightening of settings by the government, which was to respond to unsustainable levels of net migration and increasing reports of migrant exploitation. So then later in 2024, there was targeted consultation with a number of stakeholder groups, and that was on possible future changes to the AEWV scheme. After this consultation, changes to the AEWV were announced in December 2024, and really these changes aim to support employers to secure the labor and skills that they need and to help make the AEWV more nuanced, more flexible, and more responsive to different needs of businesses. As you may know, the first change took place in January, where there is no module completion requirement for both employers and employees. So the changes coming into effect on this Monday, 10th of March, aim to make it easier for employers to hire migrant workers while maintaining fair employment standards. Key highlights include removal of the median wage requirement for AEWV and SPWV, reduced work experience requirement for AEWV applicants, a simplified employer engagement with MSD for the job check process, and increased the visa duration for certain lower skilled roles, higher income threshold for supporting dependent children, reclassification of ANSCO code impacting job classification and visa pathways, and then expansion of interim visa work rights from April 2024. And in the mid of 2025 this year, the government is really looking into streamline the job check process for some compliant employers. More details will be given. So we will go into more details on each of these shortly. And we also want to highlight that both the skilled migrant category and green list categories are under review in 2025, with potential changes to the point system for SMC and expansion of trade-related occupations in the green list. So the first change that we will go through today is the removal of the median wage. So this first change is that for applications for an AEWV, as well as a current seasonal pathway under the specific purpose visa, there will no longer be assessed based on the median wage. So instead, remuneration for the proposed employment needs to be at or above the New Zealand adult minimum wage. Having no wage threshold allows employers to recruit migrants at the market rate that's appropriate for the role. Employers still need to advertise and offer AEWV employees the market rate for the position and for the workplace location too. and the terms and conditions that are specified for the proposed employment need to be not less than those for the New Zealand market for that role. The change doesn't affect existing employment agreements, and there are also no changes to the wages that AEWV workers need to earn to apply for the residence. So just to clarify, the market rate is assessed at the job check stage, but for AEWV applications that are based on job checks approved before the 10th of March, this Monday, migrants can still be paid less than the new approved rate as long as it matches the market rate at the time of assessment. So one of the most common questions we're getting from the clients is, what happens to migrants who are currently being paid at the median wage? Can we pay them less now? So our answer is that the employers need to continue paying their employees according to the employment agreement they were both signed. For AEWV holders, their visa conditions also state the minimum rate of pay. So if they are paid less than that, it means they are breaching their visa conditions. That could have serious consequences, not just for the worker, but also for the employer. So now if you are wondering whether it's possible to vary the conditions of AEWV to change the pay rate, here is how it works. So AEWV holders can request a variation of conditions on employer, role, or location, but not just for the pay rate on its own. However, remuneration can be varied, but only if it stays within the pay range approved at the job check stage, and it still has to meet the market rate. So any changes to someone's employment, whether it's pay, job title, hours, employer, it needs to follow New Zealand employment law and immigration New Zealand law, which means negotiating in good faith between the employer and the employee. The sector agreement will also be removed, and all positions will be treated equally given the removal of median wage requirements. And however, the transport and care workforce sector will be kept because they offer the residence pathway. And another major change is the reduction in work experience requirements for AEWV applicants. So previously, applicants needed 3 years of relevant experience to meet the skill requirements. From 10th of March, this Monday onwards, this has been reduced to 2 years. Under these changes, a reminder as well that the work experience duration in the minimum skills threshold should not be stated in the advertisement unless the employer genuinely requires that experience from all candidates. So the requirement for the minimum skill threshold is an INZ requirement, not a role requirement. So it's okay for the advertising submitted at the job check stage not to reflect the minimum skill threshold, as long as the migrant that's hired doesn't meet the threshold. So we believe this change will expand the talent pool, making it easier for employers to recruit skilled workers. However, employers must verify and document the applicants meet the new 2-year experience threshold. So I will now pass on to Hailey. She will walk you through the remaining changes.
Hello, everyone. For whom do not know me, my name is Hailey Long, the New Zealand licensed immigration advisor of Absolute Immigration, and assisting employers and migrants achieving their business and individual goal in immigration, New Zealand. So let's start with the change for the AEWV effective from this Monday. So sorry, the maximum duration of AEWV holders in ENSCO level 4 and 5 role is increasing from 2 years to 3 years. What this means is that if someone is currently on a 2-year AEWV of the role, such as housekeeper or any level 4 role, they will now have the option to apply for the additional year. So for employers, this is also great news because it reduces turnover and constant needs for recruitment. And for workers, it provides more certainty and a longer-term opportunity to plan their lives in New Zealand without worrying about replying so soon. And another change, which applies to to the family who wanting to support their dependent children or dependent child coming along in New Zealand. So they will need to earn so from this Monday, once again, they will need to earn at least 55844 per year if they want to support their dependent child or dependent children in New Zealand. So this is a jump from the previous threshold of $43,322.68. Sorry, it's 76 cents. So here is the key thing to note, however. So if a dependent child's visa application is lodged before this Monday, so it will still be assessed as under this old threshold. If sorry, the goal here is to ensure that the family coming to New Zealand have the financial means to support themselves comfortably. But at the same time, the government is keeping it fair by applying the old threshold to the application that already in process. Coming to the next page. So we will discuss about a little bit about the reclassification of ENSCO role. Some jobs that were previously considered level 4 or 5 are now being upgraded to level 3, which can have a big impact on eligibility for a longer term visa duration and an easier labor market process for the employer. So these roles has been shown on the first half of this slide. On the second half of the slides, where you can see level 3 classification if requiring 3 years of experience or level 4 qualification, such role, they are currently assessed as the ENSCO level 4 or 5. But if the employer it requires the role to have 3 years work experience minimum or have level 4 qualification minimum, or both at the same time, they will be able to consider as ENSCO level 4. They will be considered as ENSCO level 3 and will have a longer term visa duration and easier labor market process, as I mentioned. So this change is specific to work visa classification and does not automatically impact the residence eligibility. However, this change is different from or is irrelevant from earlier an INZ list of occupation where our care workforce role is on the skill level 4, but will be considered as skill level 3 if necessary experience and qualification requirements is met. So such role is such change will not impact or is not overlapped to, let's say, for age or disabled carer or nursing support worker or personal care assistant. They will, as long as they have a New Zealand qualification level 4 and they are working as a level 4 healthcare workers, they will be still have the access to be considered in the residence pathway as a care workforce. So next slide, please. Sorry. So now we are going to talk about the expansion of interim visa work right. So this change that is going to make things a little bit easier for people waiting on their AEWV applications. So this change will happen in April 2025. So it is not effective this Monday, but next month. So if someone is on the interim visa while waiting for their AEWV, they will now be able to keep working. So as long as they applied from either a work visa, so let's say they are working from elsewhere or they are working from another employer in New Zealand, they will be able to continue working, but working for the new work visa condition that they are going to be approved. And a student visa application, a student visa who are also going to, a student visa holder who are also going to apply for AEWV. So they will also be able to have this continuance of work right while they are holding the interim visa. So I would say I would add a little bit I will add a little bit more here. So there's important details regarding the time spent on the interim visa will now count towards the AEWV maximum continuous stay limit. Can we please go back to the previous? Yeah. So this means while people can now work during this waiting period, it does not actually extend how long they can stay in New Zealand under the AEW rule. So in practical term, migrants may end up reaching their work visa limit sooner than expected. So let's say in total, they will be allowed to stay in New Zealand for 5 years or for 3 years. This, if they ever been under a interim visa, the time on the interim visa will be also counted in their maximum continuous stay. So this is something the employer and workers need to keep in mind when planning a long-term employment. So next slide, please. So I would say for retirement village industry, the care workforce sector is something that we cannot avoid to discuss. So let's have a recap now regarding how the visa settings apply to care workers under the AEWV scheme. So for workers in level 4 or 5 care role, the maximum visa duration and continuous stay depends on their hourly rate. So if they earned at least 25 cents per hour, they can be granted a visa for up to 5 years with the maximum continuous stay of 5 years. So apparently this will apply for the level 4 care workforce care workforce, but if their pay rate is below 28.25 per hour, let's say that's level 3 care workforce, their visa duration is limited to 3 years with a maximum continuous stay of 3 years. However, if we constantly seeing if there are level 3 care workforce upskill themselves to there are level 3 care workforce can eventually upgrade themselves to the level 4 care workforce. They will be able to still have the 5-year maximum stay, but they need to apply for the new visa and inform Immigration New Zealand of their upskill. This means once again that higher wages provide longer visa stability, and this is something both employer and workers need to consider when planning for the long-term employment in this sector. So these changes are aimed at supporting workforce retention while aligning visa condition with skill level and pay rates. So now coming to the next page of the slides. Let's have a little bit sum up of everything. So level 4 and 5 visa duration are now extended to 3 years, and the income requirements for dependent children has increased. So please make sure if you are currently having any employees intended to support their child or children coming along with them in New Zealand, make sure they will meet the higher pay rate or higher salary per annum, so for them to be able to support their dependent child. And some jobs have been reclassified to level 3, which opens up better residence opportunity apparently, and a longer visa duration at the same time. And the interim visa holders can now work while waiting for their AEWV. So making things easier for both employer and workers, but please make sure that once again, we need to be aware that maximum continuous stay will also count in the time when someone is on the interim visa. So these changes are, I would say, these changes are considerable, and it is important that both employer and migrants are prepared. So if you need any help navigating any of this or provide any tailored advice specifically to your business situation or your individual situation, our team is here to provide tailored support. And that brings us to the end of the presentation. And now we'd love to hear from you guys. If you have any questions, please drop them in the chat box, and we will do our best to answer them.
Do we have any questions for us? So you can either enter into the chat box, or we have a Q&A box in that toolbox. So you can feel free to enter the questions. We can probably answer them live here. Okay, so we have one here. With the increased income threshold to support dependent children, how might this impact the recruitment and retention of care workers and support staff in aged care and retirement village settings? So this increased income threshold, I would say, when employer provides a job offer and employment contract to the overseas migrant workers, you probably want to take into consideration their hourly wage if they're able to support their family, because we all know that if a family is the migrant worker is likely to stay if the family can stay with them. So I think the consideration of the job offer and also the wage should be extended to if whether they can support the family to stay here in New Zealand on the living wage.
Yeah.
We have one question from Joe. Can we have a copy of the slides? Yes, of course. Yeah, so once we finish this presentation, we will send you the slides and also recording. So if you don't receive it, just let us know. We can probably send separately. For sure.
Any other questions?
We have a question from Lara. I'll read it out. If we have a step 3 and step 4 caregiver in our company that are paid on 2 different rates above median wage, with this change, could we apply for one job check at level 3 and support them both instead of doing 2 separate job checks? So are they level 3 and level 4 caregiver? And if you do one job check, I would say it will probably bring the level 4 to level 3 as well, because if are they getting paid differently? Maybe you can do one job check, cover both the pay range. And you probably will bring the level 4 up to level 3 as well. But if the level 4 doesn't have, say, 3 years experience, or the level 4 certificate, NZQA level 4 certificate, to be qualified as a level 3 caregiver, then I think maybe you have to do 2 different job checks. Yeah. So the issue here is if the step 4 caregiver can be qualified as a level 3. We have Greg here. Can employees currently on 2-year work visa apply for 1-year extension on the same token? Hailey, do you want to take this one?
Yes, I would confirm that that is likely the case, but well, we need to be specific on why or how come this person has the 2-year work visa, because there are few scenarios someone has 2-year work visa, but if they are as a level, let's say as a step 3 caregiver, so that may require them to that they may be able to extend their visa on the same token. But let's say if there's any other reason to make them wind up a 2-year work visa, we will look into that. We will need to look that in details for you. And there's another question. What module do we still have to do?
Managers and
Yeah.
sorry, what we were mentioning earlier is from the announcement last year, December 2024, from January onwards, employers and AEWV are not required to complete the modules anymore. So you don't have to do it anymore. It has been removed.
Any other questions? Okay. Okay, here comes another one. I will just read it. Are there any anticipated changes in classification or policy that will affect the eligibility of aged care workers or personal care assistant under the AEWV or residence pathways? So I would say for now, immigration is still giving their green signal to what they have in place for the healthcare workers regarding the residence pathway, and I don't really think the changes is imminent or will be happening over the next couple of months, I would say. But as Maggie mentioned at the beginning, we will have a further announcement from the New Zealand government regarding their further updates for the whole residence pathway settings. So we will see from there, but at this point of time, I don't think there will be any changes regarding this part for the care workforce. Yeah.
So we have one more question from Greg. If an HCA employee is paid over 28.25 per hour, what does this pathway to residence look like? Hailey, you want to take this one?
Yeah. So, well, if they are paid at above of this rate, I assume that they are a level 4 or step 4 healthcare workers. So basically, they will be able to have access to the current care workforce sector work to residence. So basically, it means once they are on this pay rate and once they are qualified as a level 4 or step 4 caregiver or care workforce, so they will be starting from that point of time, they work for 2 years, normally they will be eligible for residency. But once again, because the policy is not as what we said as of now, there's a whole lot of instruction over there. So we recommend if you have anyone who are likely to be on the level 4 healthcare workers, it'll be great that we have a tailored discussion about their option or just make a personalized eligibility assessment from there. Yep.
Do we have any more questions?
Oh, there's another one.
How can retirement village employers ensure they are compliant with the new AEWV policy changes, particularly regarding market rate pay and minimum wage obligation? So like I mentioned earlier, I actually recommend all employers document and record down your recruitment process, especially, with the new changes coming this year that Immigration New Zealand is looking at to announce a more simplified and streamlined job check process for employers who are super compliant. So this could help you to, probably be at the top of the list to be streamlined when applying for the job check. And regarding the market rate and the minimum wage obligations, I would say, I believe probably in the industry there is collective agreement that maybe most of the employers bought to pay a certain rate to healthcare workers. And then if some AEWV workers or migrant workers, they are asking for higher rate, you can definitely go and explore on Seek salary guide or Trade Me salary guide or Career NZ, and you will find market rate guidance over there. And that's the guidance that used by Immigration New Zealand as well. Okay. Do we have any more questions? All right. I guess that's it for today. Okay, so thank you so much for everyone joining us today, and thank you for your time. You have me and Hailey's contact detail and our Absolute Immigration team's contact detail. Anything or any further questions, please feel free to email us. And thank you for today. Have a good one.